Good evening, everyone. Good evening. All right, Satyam. Good evening. Good evening. So we finished articles 14 to 18 yesterday. Audio video okay? Can you all hear me? We've changed some settings on our backend. Are the audio video okay? Can you all hear me clearly and see me clearly? Please let me know in the comment box immediately. Good evening, Sarvesh. Anirudh, good evening. All right, fine. Thank you. Thank you. Thank you, bhai. See. Thank you, sir. Thank you so much. Thank you. मेट्रो तक छुड़वा देते हैं ना? अच्छा, आप छोड़ दोगे क्या इसको? अच्छा, ठीक. थैंक यू भाई. थैंक यू. डिनर कुछ? हाँ. I'll call. Thank you. All right. Thank you. Bye. Okay, so we've actually there was a huge semiconductor shortage, because of which I was not able to get the camera that I had purchased for the home setup, and now that we've been able to do that, so that's why we changed the mic and the audio setting, so that it's all a home grown setup. Thank you. All right. So we finished articles 14 to 18 yesterday, and now we're going to be studying article 19 today, and we're going to cover the pre and the mains part together for article 19, because there are direct, very probable questions that come from article 19. All right. So we're going to start with article 19. We'll first read through article 19, understand what it is, we'll understand the exceptions, and then we'll look at the mains part of it. You will find this in your mains notes as well, and we'll keep coming back to it, keep circling between the two. All right. So article 19, protection of certain rights regarding freedom of speech, etc. That's the title. Now, article 19 clause 1, all citizens shall have the right to, which means this is the right available only for citizens and not for foreigners. Now, there are a total of 6 rights as of today. There used to be 7, and the one that is no longer there related to property, and you don't have to worry about what it used to be called. So right to property as a fundamental right in the constitution were in 2 places, one in article 31 and the second was in article 19 clause 1, clause A, clause F. So clause F does not exist. Article 31, the titular article, does not exist. 31A, B, C of course too. We'll come to that later. Now, so we have about 6 rights. Let's understand what they are. We'll understand the implications of it, and then of course we'll do the analysis of things like those. So article 19 clause 1, all citizens shall have the right to, first, the right to freedom of speech and expression. Now we must understand there are a few meanings here. Speech is anything verbal, and expression means 2 things: expression of oneself and expression about oneself. There are 2 things: expression of oneself an expression about oneself and both of these are largely non-verbal in nature. Now, the most common interpretation of expression would be non-verbal, which means you will have, say, something that you write, something that one plays, something one performs, something that one projects, stuff like this. I'll give you the exact interpretations also. The larger forms of expression, and this is where most people don't get it right. Expression is not just about your opinion. Expression is also about how you express yourself. One of the ways you express yourself is no doubt through what you say, through what you write, through what you perform, and all of those things. But another very important form of expression is, say, your gender, your orientation, your clothing, your cuisine. Those are also forms of expression, right? So, which is why when we look at LGBTQ rights, transgender rights, homosexuality rights, no doubt the primary fundamental right that we talk about is Article 21, because personal liberty means the liberty to, love who you love, identify your gender, and so on and so forth. But it is also a method of expression. So you will see that, issues like LGBTQIA, issues of transgenders and so on and so forth, no doubt fundamentally are about Article 21, but also have a correlation to Article 90. Now here, from this specific right, we will understand, films, we'll understand OTT platforms, we'll understand stand-up comedy, right? We'll understand paintings, cartoons, just think of everything that you can. This is what is called your expression, right? Expression, how you are expressing yourself, right? And therefore, you would also have the origin of press rights, journalistic rights from here. So that's your first right. The second right is to assemble peaceably and without arms. So this also originates, this is basically saying that you have the right to form any association or whatever it is, but for that you have the right to first meet publicly. You have the right to be able to gather collectively. So to assemble peaceably without arms. Now a curfew or a lockdown are issues that sort of arise from here. Then you have the freedom to form associations or unions, and added through a constitutional amendment, the 97th Amendment, cooperative societies, right? Now, to form associations and unions is essentially to have a sense of collectivism, to have a sense of fraternity, which is also enshrined in the preamble. But if you add A plus B plus C, what do you get? You have the freedom to speech, you have the freedom to assemble, and you have the freedom to form associations. So all your dissent related issues are sort of important here. For example, sedition, for example, hate speech, all of these therefore also become important, right? Then these are your three basic fundamental rights. Then you have the right to move freely throughout the country or throughout the territory of India. This, in the Menka Gandhi case, has an interpretation that you have the right to India, but you also have the right to exercise an Indian fundamental right no matter where you are in the world. Now that is a very blanket statement that I have made. What it basically meant was, and we'll cover this in the Menka Gandhi case later on, but what this basically means is that an Indian is protected by Indian fundamental rights in India, right? So the right to move freely throughout the territory of India. Now in the modern day context, we have something called inner line permits, We have certain, secure areas where, permissions are required or entry is permitted or restricted and so on and so forth. So that's your Article 19 Clause 1 Clause D, right? Now, I will organize this from the mains perspective, don't worry. For the pre, this is more than enough, right? Now, uh, Article 19 Clause 1 Clause E, to reside and settle in any part of the territory of India. So this is no longer an issue anymore, but Article 370 correlated to Article 35A were sort of restrictions on these rights. In addition to this, you have certain protections that are given to scheduled areas. Now, these are of course certain, implications of this right. There are no contemporary issues as such that come out of this right. Anyway, this was the right to property, one of the dimensions of right to property, which has been eliminated through the 44th Constitutional Amendment. This is where right to property was removed from the Constitution of India. So the right to property in 31 and Article 19 Clause 1 Subclause F do not exist here. Then you have the last fundamental right, the right to practice any profession or to carry on any occupation, trade or business. Now this in the modern day looks at some grey areas of businesses. There's of course prostitution, but I will discuss the legality around prostitution in the context of Article 23, which is basically your freedom against exploitation, human trafficking, forced labor and so on and so forth. Because one of the most probable outcomes of human trafficking is prostitution. Then of course you have restrictions on professions relating to drugs, not medicinal drugs, not the pharmaceutical drugs that we're talking about. We're talking about recreational drugs. And over and above this, you also have issues nowadays in the modern world with respect to, say, online gambling, the mobile Premier League issue, the Dream 11 issue, and so on and so forth. Okay, so what do we understand from here so far? We understand that Article 19 gives us certain basic fundamental rights, and then Articles 19, 2, 3, etc., etc., etc. are going to give you certain reasonable restrictions to those very rights. So what we're going to do now is, we're going to on a fresh page write the fundamental rights in the left column and look at the reasonable restrictions and understand how cleverly were these sort of conceptualized by the people of our country. Okay, so let's start. All right. One second, please. Sir, good evening. सर क्लास चल रही है ना सर, बताइए ना सर. अच्छा अच्छा, ओके 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 ओके, सॉरी सॉरी. राइट, so let's start from Article 19 and let's understand the broad freedoms. So on one column we will look at the freedoms or the rights available, and here we will look at the restrictions that have been identified within the Constitution itself. So we've got Article 19 Clause 1, and then we have Clause A, Subclause A, Subclause B, Subclause C, Subclause D, Subclause E, and F is not there, Subclause G, right? So Article 19 Clause 1 Clause A is speech and expression. Article 19 clause 1 subclause B is assembly without arms. Clause 1 clause C is to form unions, associations or cooperative societies. D is to move in any part of the country as possible. So move freely throughout India. E, to reside anywhere in India. These are broadly what the rights are. And then of course you have the freedom of profession, trade, etc. Right? Now on one hand, we know these are our 6 rights that have been given to us. We also understand F does not exist because it was related to property. It was removed by the 44th Amendment of 1978. Okay, all right. Now that we understand this, we're clear with this, we move to our restrictions. So, all right. Article 19 clause 2. Now if you notice, Article 19 clause 2, these restrictions that we are talking about, Article 19 clause 2 was not a part of the original text of the Constitution. In fact, you would be very, very surprised to note that these were added from the very first amendment to the Constitution. These were added in the very first amendment to the Constitution. So it is very interesting to note, and the first amendment comes from 1951. That is when we don't have India's first ever elections and the Constituent Assembly doubles up as the interim parliament, and therefore it's very ironical to note that the very people who gave us the fundamental rights are also the very people who are adding restrictions to the fundamental rights. Okay, so this was added in the first amendment of 1951, and now let's understand this. There were certain parts from retrospective effect and all which were sort of changed. So what it is, not the entirety but some parts were changed. So nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law. This means both the center and the states. This means that either if there is already a law existing or you have to make a law in the future, insofar as such the law imposes reasonable restrictions on the exercise, and this is where the Supreme Court is going to have a field day. Every issue is going to be, is the law reasonable enough? Is the law, the restriction given by the law, is this a type of a reasonable restriction? Does it come under the larger domain of reasonable restrictions on the exercise of the right conferred by the subclauses in the interests of? And there were certain changes that were made. You don't have to worry about the amendment. This is the 16th constitutional amendment of 1963, but don't worry about it. You just need to know what it is. So what are the reasonable restrictions? Sovereignty and integrity of India, security of the state, friendly relations with foreign countries, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense, right? So let's write them down. Let's write them down separately. Okay. And please start making these things in your notes also. This is important, right? So what are your reasonable restrictions? Your reasonable restrictions are, first, sovereignty and integrity of India. 2, security of India. 3, first sovereignty and integrity, second security. 3, friendly relations. With fellow countries, friendly relations with fellow countries. Okay. Then comes the next layer, public order, decency or morality, contempt of court, and defamation. Or incitement of an offense. Now you can see clearly how the issues that we are talking about are arising from here, right? We were discussing this as contempt of court as an example in Article 14 also, that you can speak whatever you want to, but don't scandalize the reputation of the court, right? You can speak whatever you want to, but your speech should not instigate people to commit a crime, and this is the birthplace of hate speech, right? Decency and morality, right? For example, you have the right to express what you want to, however you want to, but then does that mean people of the same gender should be allowed to be intimate with each other? Now, according to conventional orthodox notions of India, it was considered as indecent or immoral, which now of course the court has said, very rightfully so, that homosexuality is not something which is indecent or immoral, right? Similarly, sedition, right, which disturbs public order or security of the state or friendly relations with the state, right? So you will see that the issues are coming out from the right and the reasonable restrictions itself. Yes, the Sulliby app and all of those things. Yes, absolutely. Now, we'll do those issues in detail, because in the mains exam, you don't get technicalities. I'll discuss the previous year questions. They ask you general questions. Does right to freedom of speech include hate speech? Why are films considered so separate from other forms of expression? Those are the general issue-based questions they ask. They don't ask technically complex legal question, right? So on and so forth, right? Of course, of course. Now, we've understood that these are the broad. I'll be very clear for this. Do not memorize this. Do not memorize this at all as far as the prelims is concerned. You don't even have to memorize the technical details here as far as the mains is concerned. As long as you broadly know these rights and you broadly understand that these are the kind of exceptions, that is fine. But certainly for the prelims, you don't need to memorize it. Don't waste your time doing so, right? Now let's look at Article 19 Clause 3. So Article 19 Clause 3 says, nothing in subclause B, which means Article 19 Clause 3 is to further explain Article 19 Clause 1 Clause B. This was for Article 19 Clause 1 Clause A, as you saw here. Now here it is B. Nothing in subclause B shall clause of the said clause shall effect the operation of any existing law in so far as it imposes, which means what is missing? Or prevent the state from making any law. Now that has been added here, or prevent the state from making any law in the interests of sovereignty and integrity, or public order, or reasonable restrictions exercised on the exercise of the right conferred by the said clause. So if you see, the highest amount of restrictions as clearly as you could spell out were in freedom of speech and expression, which is why most issues originate from freedom of speech and expression, and all the others sort of add up to it. And very interestingly, when you add sovereignty and integrity, these are technically very vague words. What affects integrity and what doesn't affect integrity is very subjective. It depends on the point of view of the government. It also depends on how the government looks at it, what the citizens understand it to be. So it's not that clear. It's not that black and white. So let's note down the reasonable restrictions that we're talking about. So again, sovereignty and integrity remains the same. Sovereignty and integrity remains the same. This is a common reasonable restriction to both Article 19 Clause 1A and Clause 1B. Then you have public order, which is the second part. You have public order here. And then you have any other reasonable restrictions that can be made, or say any other reasonable restrictions, etc. Now you would understand why assembly without arms has a necessary impact on public order, because if you're just assembling without saying anything, you are not going to cause contempt, you are not going to hamper the security or the friendly relations. And even if you do, so technically with the word sovereignty and integrity added here, it almost covers everything else. A lapse of security is a question on integrity or sovereignty. A lapse of friendly relations is also a question mark on the sovereignty and integrity. There could be arguments made on either side, which is why you have to be very careful with certain proceeds in the country, right? Now we move to the third part. Right. Now we're done with the third part. We now move to the fourth clause. Fourth clause is for clause C, which is right here. Associations and all of those things. So Article 19 clause 4 is an exception to Article 19 clause 1 subclause C. Okay. Article 19 clause 1 subclause C. Nothing in clause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevents the state from making any law imposing in the interest of the magical words sovereignty and integrity, or public order, or morality, reasonable restrictions on the exercise of the rights, right? So there is a little bit of open end here. So you've got sovereignty, public order and morality. Okay. So sovereignty and integrity, common, public order, again common, and morality, which is common to this part, right? So obviously the organizations that you make They can't be, plotting against the government. You don't have the freedom to form, All India Al Qaeda Friendship Association. You can't list, Al Qaeda on LinkedIn. You can't have, Al Qaeda hiring on Naukri.com and things like that. Public order means maintenance of law and order in a society, right? So riots are a violation of public order, bunds are a violation of public order. We'll cover these, the rights to protest, the rights to strike, all of those things we will understand, right? So this is Article 19, Clause 1, Clause C, and these are your reasonable restrictions. Then we are going to look at Article 19, Clause 1, Clause 5, which is for D and E collectively. Yeah. So these are exceptions to Article 19, Clause 1, Clause D and Article 19, Clause 1, Clause E, which is basically to move anywhere and to reside anywhere. So what are your basic exceptions? Nothing in subclauses D and E of the said clause shall affect the operation of any existing law insofar as it imposes or cannot prevent the state from making any law imposing reasonable restrictions on the exercise of the rights by the said subclauses, either in the interest of general public or for the protection of any interest of a scheduled tribe. Now, do you understand why I said scheduled areas, protection of scheduled areas, inner line permits? Why are they legal? Because the Constitution specifies that protections can be made for a lot of these people, right? So reasonable restrictions in the interest of general public or protection of interests of any scheduled tribe. Very, very vague. Very interestingly, you do not find sovereignty and integrity here, thankfully. So here you have public interest and you have interest of scheduled tribes in public interest / interest of scheduled tribes. Now, for the purposes of this exam, don't worry about the technical differences between what is public order, what is public interest, what is decency. We'll do them from an issue by issue basis and we'll understand what are the kind of issues that come out and how should we be discussing those kind of issues, right? So that is the case. Now D and E. Now we are left with the last one. The last one is right here. We'll quickly go through it. There you go. Nothing in subclause G of the said clause shall affect the operation of law, which is basically, this is an exception to Article 19, Clause 1, subclause G, so far as it imposes or prevents the state from making any law imposing in the interest of the general public, reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular, nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to the professional or technical qualifications necessary for practicing any profession or carrying out any occupation, trade or business, or the carrying on by the state or by the corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion, complete or partial, of citizens or otherwise. This is an extremely important article. So let me tell you what it basically means. It means you have the freedom to trade, business, do whatever you want to, work in any way you want to, no problem, right? Now article 15 clause 6 15 clause 6 gives you a general restrictions that in the interest of general public we can, you know, restrict some of your work, some of your business, some of your trade, and so on and so forth. Like, it's in the interest of general public that gambling is illegal in the country, except of course it's horse betting, and that also is controlled by the state. So it is in the interest of general public. Like, for example, alcohol. If somebody wants to open an alcohol shop, now alcohol is in the state list, which means every state can decide how they want to run the business of alcohol in that state. Now, some states allow for everybody to have an open license. Some states say that we will own all alcohol shops. Some states say that there will be no alcohol at all sold anywhere in our state. So these are the kind of laws that you can make because the state has the right to do so. It's in the interest of general public. So you would ask, sir, for example, in Gujarat, alcohol is prohibited. It's a prohibition state. It's a dry state. Does it hamper the freedom of profession of people who want to have alcohol shops? Yes. But the government, in general interest or in the interest of general public, can shut anything down however they want to. There's absolutely nothing wrong with it, as long as, of course, it's reasonable, it's fair, because alcohol has a health implication, alcohol has a moral implication, alcohol has a societal implication. It is far deeper than just, you know, alcoholism. It is also one of the reasons why domestic violence happens. It is also one of the reasons why vehicular accidents happen. It is also one of the reasons why road rage happens, why, you know, public fights happen. So alcohol has a lot more to do with a lot of other issues than just alcoholism. So can the government, for example, restrict it? Yes, absolutely they can. No. Now let's come to the two sub-clauses. Please understand what are these. You have the right to become a lawyer, no problem at all, become a lawyer. But remember, in governance, I taught you, our education lectures, I taught you the regulation of education. We spoke about how education is almost heavily regulated sectors. We have general education, technical education, and professional or licentiate education. Remember this, where I discussed that licentiate education is education wherein you require a license to practice, and you can only give a degree if the government authorizes you to give a degree. Absolutely, it's completely under the ambit of the state, right? So that is how it is. You need a license to become an architect. You need a license to practice law. You need to be, you know, a certified chartered accountant, a certified company secretary. You need to have a flying license to be a commercial pilot. You need clearances from the Director General of Shipping. You need a medical tests and everything done if you're a pilot or a, you know, or a shippy or so on and so forth. Can the government make laws like these? Absolutely. Yes. No problem at all. If you're a stockbroker, you have to be registered with the stock exchange. Can the government make those qualifications? Yes. Now you can only trade through demat accounts, dematerialized accounts. You don't have a physical exchange of share papers. Can the government make a qualification like that? Absolutely yes. So that is the exact explanation. Yes. Do you need a license, or do you need a license to open a pharmacy shop or a food and beverage you know, restaurant? Yes, the government can make any qualifications, any professional qualifications, technical qualification that it's needed, right? Now, this is for anybody who's working in a private sphere. Clause 2 is about anybody who's working in a public sphere, okay, in a public sphere. What this basically says is that the government can make any law wherein the government can decide if the work is being done by the government, can it exclude completely or partially citizens? Are citizens allowed to do the same kind of business as governments can? Like, for example, we've had, for now we've slightly opened it up in defense, in space, in railways, in our earlier days in aviation, in telecommunication. Only government was the one responsible. Now we've slowly started opening up. Remember, BSNL and MTNL were your only telecommunication providers. Railways has been a government owned monopoly for so many years. ISRO, right? Bhabha Atomic Research Energy. You can't perform yes, Madhvendra, I'll do that. You cannot perform a nuclear test as a private player. You're forbidden. You ऐसे नहीं कर सकते कि मैं यूरेनियम खरीद के आया है, अब मैं कॉलोनी के पीछे बम फोड़ेगा, पोखरन खेलेगा. ऐसे नहीं कर सकते. Not allowed. The government has prohibited you from conducting those nuclear tests, right? So nuclear energy, you can't do that. The government can exclude people from getting into it. Like private armies in India cannot exist. Private armies are not existent in India. You can't have your own army. कि मेरा आर्मी है, मैं अपना करेगा, ऐसा नहीं होएगा. ठीक है? अंडरस्टूड दिस? क्लियर कि नहीं, मैं अपना पार्लियामेंट बनाएगा, अपना खेलेगा, ये नहीं कर सकते. So these are your restrictions. So what are your restrictions? Let's put them up. Your restrictions here are fairly simple ones. General public and then the rest. General public interest, or the same thing as public interest, common to here and here. Then technical or professional qualifications can be made, and then exclusion from certain works. Exclusion from certain works. ठीक है? क्लियर? अब सब कुछ यही तो है. अब now of course we'll do a proper layout of this and I'll tell you. अब मैं यहाँ लिखूँ freedom of the press, मैं लिखूँ freedom of let's say if I write surveillance, right, which is again an issue of 19 and 21. I write for example sedition, I write for example hate speech, I write censor board or censorship of cinema, so censoring of cinema. I write OTT regulations, right? I write anything in that order. सब कुछ यहीं से तो निकल के आता है, right? Of course, most of the issues are from here. There are some correlative issues here and here, and they have of course the maximum number of reasonable restrictions. ठीक है? Clear on this? Understood? कितना खुद से बताओ. इसके बाहर का भी पूछेंगे प्री में? नहीं पूछेंगे. कुछ नहीं पूछेंगे इसके ऊपर, कुछ नहीं. इतना कर लोगे प्री में, कोई क्वेश्चन इसके बाहर से नहीं आएगा, राइट? आसान था? कुछ मुश्किल लगा इसमें? Are you able to see where the issues are coming from? They're coming from here and they're coming from here. That criminalizing sedition, is it a reasonable restriction under security, friendly relations, public order, decency, incitement of an offense? क्या ये है कि नहीं है? That's it. हम और इसको करने का बहुत सिंपल तरीका है. हम पढ़ेंगे व्हाट इज सेडिशन, व्हाई इज इट इन द न्यूज़, व्हाट इज द सुप्रीम कोर्ट व्यू ऑन इट, व्हाट शुड द लॉ ऑन सेडिशन बी. थोड़ा पढ़ो, आगे बढ़ो, सिंपल इकोसिस्टम, राइट? ओके, a capital A doesn't, a small 2 can, yes, yes. Roman numeral 2 can, yes, sir. Good. Now you can take a 5-minute break and then we will start. You can take a 5-minute break, then we can start the means issues of Article 90. ठीक है, चलिए. All right. Welcome back. Good evening. So let us start. So we are now going to look at the issues pertaining to Article 90 as they are relevant for the mains exam. Okay, we'll keep referring to our mains notes, and I'll give you some additional information that you can annotate or you can note down in case you wish to. Otherwise the mains notes are enough, but I'll give you some detailed understanding to sort of give you context and how things are done. So when we look at issues pertaining to Article 19, we look at it in a multiple set of frameworks. The first and the primary form is we look at issues from a dissent perspective, right? We look at issues from a dissent perspective. Now, your ability to disagree with the government, your ability to question the government and so on and so forth. Pankaj, I'll discuss this in exploitation. Non-commercial prostitution is perfectly legal in India. So under dissent, what are the things that we should be discussing? We will discuss the issue of sedition. We will discuss the issue of hate speech. We will discuss the issue of the right to protest, and does that include the right to strike, right? Once we've understood these three basic dissent related issues, we will then move to the next category of issues. These are issues which are from the point of view of censorship, in which we are going to understand censorship of cinema in the context of the Central Board for Film Certification. This has been in the news over the last 1 year because of the abolition of the censor tribunal. So that is one issue. Second, we will understand the issue of the regulation of OTT platforms. We will understand how Netflix, Amazon, Hotstar, Disney Hotstar, all of those work. So we'll understand those. Then we will understand the third set of issues which are pertaining to the media or to the press per se, in which we will understand the rights of journalists. We will understand the rights of press corporations or media houses or media organizations. So these are the two media related or press related issues that come to the floor. And then we also look at certain derivative rights. We look at certain derivative rights. Now, under derivative rights, we understand that if I have the right to freedom of speech and expression, and I have the right to have an opinion of the government, and this right is available only and only against the state, then for me to have an opinion on the government, I should be able to have information of the government so that I can have an opinion on the government, and that is extremely important. So what we need to do is, for me to have a question or for me to have an opinion on the government, I should be able to have information about the government. So that is why through various Supreme Court judgments, we have understood that India has something called the right to information, has something called the right to information, which is an implied fundamental right under Article 19, right? And apart from that, if right to life could also correlate to right to death, then the right to speech, does that also mean the right to freedom of silence? Does that also mean the right to freedom of silence? Okay, so in these ways, in these manners, we understand that these are broadly the issues that are relevant as far as Article 19 is concerned. Now, events will keep on happening. For example, in hate speech, you had the Haridwar Dharm Sansad issue. With protests, we've had the Lakhimpur Kheri issue, the farm laws protests, the CAA protests. With sedition, we've had the Kanhaiya Lal issue. We've had some recent judgments. I'll cover all of those, so don't worry about it, right? With censorship, the abolition of the Film Certificate Appellate Tribunal, politicization of appointments to the censor board. This happened in 2014. So in 2014, there was a question, why are films so separate from every other form of expression? We've had the IT rules. Now the IT rules are important for two reasons. One is they have given you a regulatory framework for OTT platforms, and the IT rules of 2021 under the Information Technology Act have also asked social media companies to disclose the originator of a sensitive message which could have potentially caused communal riots or any other forms. So the IT rules issue, I'll write the current context here. The IT rules 2021, here the abolition of the censor tribunal. This is called the Film Certificate Appellate Tribunal in technical terms. With respect to hate speech, there has been the Haridwar issue. With respect to protests and strikes, there have been the farm laws issue relating to the Lakhimpur Kheri problem, and of course the CAA protests, right? With sedition, most recently a veteran journalist called Vinod Dua, he is no longer alive, unfortunately, may his soul rest in peace, but he was charged with sedition because of some things he said with respect to the way this country handled the pandemic. With respect to journalists and press corporations, the most recent issue has been that of Pegasus, wherein several journalists, their phones have been, or their devices have been under surveillance. That's also a privacy issue, but it also affects the freedom of the press. If it affects the freedom of the press, then it will also be an issue of Article 19. Then with respect to derivatives, yes Ashish, of course, with respect to derivatives, we've seen certain amendments that have happened to the right to information, wherein the Central Information Commission and the State Information Commission, their powers have been diminished. I'll cover this in bodies later on, but this is the larger framework under which we are going to be operating as far as Article 19 is concerned. And if we're able to answer most of these questions, we should be fine. We should be able to handle any question that comes in the mains exam. Now, as far as the mains exam is concerned, we have basically seen one question on hate speech, one question on cinema, and another one on Section 66A of the IT Act, which was yet to be declared unconstitutional by the court, and it was in the news. So the question asked you, is Section 66A a violation of Article 19 as far as the Constitution is concerned, which is again an application of dissent and the censorship or regulation of online media, right? So these are the kind of questions that have been asked. It is also important to point out that so far since 2013, most questions ever since the pattern has changed, most fundamental right related questions, most issue based questions have come indeed from Article 19, then of course from Article 21, where you've had questions on privacy basically. Okay? So I hope we understand this. I will give you 2 minutes, 1.5 minutes actually, to just take a note of it, and then we will start with sedition law. Yes, Nikita, but right to be forgotten, I'll cover in the context of privacy. It's correlative to that. I haven't forgotten the right to be forgotten. Okay, so don't worry. Devendra, what is delegated legislation is not in the context of what we are discussing. You can ask me that question later on. It's nothing but a bunch of laws or bunch of rules actually, which a law allows the executive to form without being passed by the legislatures. Central Information Commission and State Information Commission. All right. Now let us start with sedition, our first issue under Article 19. Now, when we discuss sedition, we must understand what are the questions that can come as far as the exam is concerned. Okay? So, what are the basic things that we need to know? Question number 1, we need to know what is sedition. Then we need to know what are the important Supreme Court judgments on sedition. And third, should sedition be removed or declared unconstitutional or invalid from the Indian legal system? As long as we are able to answer these 3 questions, I think we are perfectly capable of solving any question that can come as far as sedition is concerned, right? Now, I'll first tell you what sedition is and how does it correlate to Article 19, and then we'll do the remainder 2 questions. Okay? So, for that, I'll take you to our slides, right? Yeah. Okay. Sedition. And I'd like to begin our discussion on sedition right? I'd like to begin our discussion on sedition by a cartoon which was made in 1962 by one of India's most veteran political satirists, who, if in my opinion, were present today, would definitely be facing sedition, right? So R.K. Lakshman, he was a legend. He was an absolute superhero in terms of how accurately he was able to depict the issues of our country in just a cartoon. Now here you can see that a police officer is taking an individual, of course with the police officer to, I'm presuming, the police station or jail, and the common man here is looking at what's happening, and the police officer is telling the common man, of course you were not spreading humors, the charge is that you were spreading facts. So that's the irony behind sedition. Now let's begin our understanding of sedition, then we'll get into the technical details of it, right? Now, so what is sedition? As you can notice, sedition is under 124A, section 124A of the Indian Penal Code, which means that this is a criminal offense. If a person commits sedition, then the person has to go to jail for it and pay a fine, or both, or so on and so forth. Penalizing anyone who, by words which are either spoken or written, or by visible representation, or by otherwise, attempts to bring dissatisfaction, hatred, or contempt against the government which has been established by law. So if somebody is instigating people against the government, right, or against the government which has been legally established, should be a crime. Now, as you would understand that this section, just as the section, is incredibly vague, is extremely ambiguous, and therefore can be a breeding ground for a plethora of abuses, because anybody asking people to collectively raise a voice against the government would therefore technically be committing sedition, which is why there has been an urgent need of the Supreme Court to give an interpretation of sedition, to give an understanding of sedition, so that we are able to get some narrow interpretations to it. We need the Supreme Court to restrict how this law can be implemented. Now, as you would understand, Indian Penal Code dates back to 1860, which is immediately after the revolt of 1857, and you would therefore understand why a law like this would perhaps be important for a colonizing country. Why would it make sense for the British to have a law criminalizing sedition in a colony? Because the British government was a government indeed by force. While it was a government by law, there were regulating acts, there were government acts, but the sheer ability to formulate those acts, to implement those acts, that was illegal in the first place. They had no right to rule over us. They had no right to govern us, which basically means that it could have been justified in the colonial era, but definitely not today. So of course, today it has been widely criticized for serving as a restriction on the freedom of speech and expression. Now, even though the explanations of the section make it clear that only attempts to excite hatred, contempt, or dissatisfaction can lead to sedition, and lawful criticism with a view to obtaining change does not amount to it, the law of course has been widely abused. There is one thing to write something in the law, and there's a completely other thing to see how the law is actually practiced in modern day form, in modern day society, and so on and so forth, right? Now, of course, we'll come to how the law is, but this fundamentally answers our question: what is sedition? Where does it exist? And what happens is that you are fundamentally restricting what is called your Article 19. I'm going to come to the last line later, so don't worry about it. Now, you must understand there are several Supreme Court judges, Supreme Court judgments. I'm going to come to that in just a bit, but do you understand how Section 124A is a question mark on Article 19? If you have the freedom of speech and expression, the right to a peaceful assembly, the right to a union or an association, you can speak assembled somewhere as a part of an organization, questioning the government. So where does the line of dissent end and sedition begin? Which is why, as much as this is a legal issue, it also happens to be what is called an ethical issue. So you can actually quote sedition as an example in your ethics answers as well, on conflicts of governmental actions. On one hand, you want to preserve the harmony of a society, and on the other hand, you have to make sure that the people have the right to speak their minds. So the balance between societal harmony and the dissent, that balance is on the fulcrum of what is called sedition, right? Now comes my interesting part, the part that I love the most, walking you through the history of judgments on Supreme Court, by the Supreme Court and by other courts as far as sedition is concerned. And you will be very surprised that, the judgments are quite fluctuating in their opinions on sedition. Okay, so we're going to come to that right about now. So this fundamentally answers this question. We now move to the evolution of judgments on sedition. I will be very clear on this. All the judgments are not important. Only one judgment really is, and I'm going to come to that in just a bit. Okay, so let us start. So we're going to understand the timeline of judgments on sedition. The timeline of judgments on sedition. Okay, so let me just walk you through the history of it, and then we'll understand things very clearly. I would recommend that you draw this in your notes because this is something which I have recently sort of reorganized. It will help you understand sedition better, if you may please. Okay, so let's start. The story of sedition starts from the very first year, right? In fact, one of the very first few years of India's independence, and starts from the year that the constitution is in force. Okay, in fact, it starts from 1950. Then there is another judgment. So the 1950 judgment is from the Punjab and the Haryana High Court. We had a collective High Court. I'll write this slightly on the left side. So the High Court of Punjab and Haryana. I hope you're able to understand this. Then the next judgment is in 1958. I'll tell you which ones are important for the exam. This is to make you understand what is the case here. Okay. Then you have the 1958 judgment. This is from the Allahabad High Court. Okay. Then you have just a few years later, in 1 year's time, in 1959, you have a judgment again by Allahabad High Court, so I'll write it collectively. Then comes an extremely important case, the case which perhaps changes almost everything, and this is where the Supreme Court for the first time gives an interpretation on sedition. Some of you will know this as the Kedarnath case. I'll come to that. Then for 50 years, we don't care two hoots about sedition. Then in 2016, a petition is again filed in the Supreme Court, and what you will not find in most of the newspapers is that there was another petition which was filed in 2021 at the Supreme Court, right? So this is the journey, and I'll give you the names of the cases and I'll tell you about the cases so that you can listen to me, and that's pretty much it, right? So let's start. The 1950 case, and this case is not important. This case is not important. Only the analysis of the first three cases is important. The details of the first three cases are not important. The only case that you really need to know is the 1962 case. That is it, right? So let's understand this, and of course the recent ones, because they add contemporary context. So you've got the 1950 case, which is Tara Gopi Chand versus State. Tara Gopi Chand versus State. Okay. Then you have Sabir Raza again versus the State. You would understand these are criminal offences. Criminal offences are always against the state, or a specific one. Now reorganization happens, states are formed. Now specific states are going to be named, right? Okay, right. 1959, extremely important judgment actually, called Ram Nandan versus State. Ram Nandan versus State, and we've mentioned the state here, the state of UP. The state of UP. And then comes our blockbuster judgment, which is Kedarnath versus state of Bihar. Versus state of Bihar. Kedarnath versus state of Bihar. Okay, understood? Or Kedarnath Singh versus state of Bihar. Kedarnath is also fine. Then in 2016, you have somebody challenging the constitutionality of it and all. It's called, Common Cause versus Union of India. Then in 2021, Aditya Ranjan versus Union of India. Common Cause is an NGO. We'll keep coming to them because they have filed multiple petitions, for example, challenging constitutionality of 35A. They are also responsible for filing a petition which evolves euthanasia and so on and so forth. And then this is Aditya Ranjan versus Union of India. Okay, Aditya Ranjan versus Union of India. Now, join me for a discussion. join me and just listen to what I have to say in the next few minutes. I'm going to take my chair, I'm going to sit down, and I'm going to narrate a lovely little story to all of you. Okay? All right. So let's start. I'll give you 1 minute to copy this down and then we'll start. 1.5 minutes actually. (1950/51) because the judgment was reported in 1951. So both the years are correct. All right. In 1950/51, the Punjab and the Haryana High Court, and you will not believe what I'm going to say next. The Punjab and the Haryana High Court declared sedition to be unconstitutional. It declared sedition to be unconstitutional, which means nobody in Punjab or Haryana after this judgment could be charged with sedition because it is the High Court. A law has been challenged in the High Court, and the judgment of the High Court is only applicable within the territorial jurisdiction of the High Court, which is the state. Okay, so in the very first year of India becoming India, post the Constitution, the Supreme Court took the High Court took such a strong and a brave stance. Such a strong and a brave stance. Now, you would ask, why would the High Court of Punjab and Haryana say so? Punjab and Haryana, a High Court, basically a twin judge bench, they said that sedition violates Article 19 because the exceptions given under Article 19 Clause 2 nowhere mention or are inclusive enough to cover sedition. When we look at the exceptions, when we look at the restrictions that can be given under Article 19 Clause A, 19 Clause 1A, and we look at the restrictions under 19 Clause 2, this is Article 19.2, 19.3, 19.4, 19.5 and 19.6. So under Article 19 Clause 2, criminalizing sedition is applying these restrictions unreasonably. It is unconstitutional and it is unreasonable because a democracy will always have changes in ideologies, will always have changes in the rule of politics, will always have changes in our rulers, which basically means a democratic country should never ever look at criminalizing sedition. Okay, criminalizing sedition, right? So this was held by the Punjab and the Haryana High Court, which means in the first year of India, we were able to come up with such a brilliant judgment by the High Court of Punjab and Haryana. About a few years passed, and then in 1958, the Allahabad High Court was also faced with a similar situation, wherein there was a constitutional challenge to sedition. All right. Now, what has happened was, and let's look at this. In 1958, the Allahabad High Court, while it was, examining the constitutional challenge to sedition here itself, right? Now, the judges in this viewed sedition, or viewed any criticism of the government, or a member of parliament, or a government policy, as an exercise of the right to freedom of speech and expression. In fact, the Allahabad High Court in 58 said, if you're criticizing the government, if you're criticizing a politician, if you're criticizing a policy, it is your fundamental right under Article 19 Clause 2 to do this. It is your absolute fundamental right under Article 19 Clause 2 to do this. And therefore, we must not look at sedition with such a sharp eye. And such a speech which criticizes the government or its members should not be penalized, even if it is disrupting public order. If your speech is criticizing the government and because of it there is public order disruption, even then it should not be sedition. Just look at, the interpretation of the Allahabad High Court. Okay. And then, of course, the High Court also very clearly held, they said that, boss, just because there is a disruption of public order, it does not lead to necessarily threatening the security of the state. Okay. It does not lead to threatening the security of the state. I mean, if you just go back and look at the provisions, even if it is criticisms of the government is not violating public order. Even if it is violating public order, it is not sedition. And even if public order is violated, it does not mean the security of the nation is violated. So don't have your leeway, don't try to, unnecessarily abuse the law on sedition. That is what the Allahabad High Court had said. Okay, understood this? And the Allahabad High Court said the only way you can, overthrow the state or, remove democracy is by mutiny or is by rebellion, right? That is how a republic or a democracy is destroyed. Not by, it's not destroyed, by certain speeches. It's not destroyed by public order. So don't be so protective or so sensitive about sedition. Okay. Now, the court did not give a clear-cut answer on whether sedition should be unconstitutional or not, but it said something very interesting, that criticizing the government is not sedition, and even if a speech is disrupting public order, it is still not sedition, and disruption of public order does not mean disruption of the security of the state. Okay? This is the Sabir Raza case. A year later, Allahabad High Court, right? A year later, Allahabad High Court had another golden opportunity, and this time they did not, think twice. They didn't bat an eyelid. This is why this case is actually very interesting. So Ram Nandan, right, who was basically an agricultural labor activist. Ram Nandan was basically an agricultural laborer activist. Okay. And he had accused the Congress government of, failing to address the poverty situation in UP, malnutrition rates were through the roof, deaths were through the roof, and the primary targets of all of this were of course the landless laborers. And then he said that the farmers should come together, make, form an organization, and should overthrow the government, and we should have what is called a farmers' rule. Okay, now here is interesting. What the Allahabad High Court said was, just because there is a possibility of public disorder or a violation of public order does not mean that public order has actually been violated. Does not mean that public order is actually violated. Do we understand this? Is this clear? Okay. And therefore, in Ramnandan, Allahabad High Court did exactly what the Punjab and Haryana High Court had done. It also declared in 1959 sedition to be unconstitutional. So by 1959, Punjab, Haryana and UP, you could not file a case against anyone for sedition, because the high courts of these three states had declared sedition as unconstitutional. All right. Now comes the Supreme Court. And when everybody expects the Supreme Court to, probably take the work of the High Court forward, what happens in the Kedarnath case is actually quite interesting. So in the Kedarnath case, something was very interesting. So what happened in Kedarnath case was, see, Kedarnath as a person was a member of a political party in Bihar. The political party was called the Forward Communist Party of Bihar. The Forward Communist Party of Bihar. Okay. Now, in a place in Bihar, called Barauni. Yes, in a place in Bihar called Barauni. 10 years ago, in 1953, Kedarnath had given a fiery speech in Barauni in 1953. Very, very fiery speech. And this is around the time when land reforms were happening. He accused the Congress government of absolute corruption. He accused Vinoba Bhave, you might have heard of Vinoba Bhave, Acharya Vinoba Bhave, of, misusing or misappropriating the land reforms that were happening. And therefore, he was, basically questioning Vinoba Bhave that, how land was being redistributed was not done in the right manner, and, who should have been given land were not being given land, right? So this was essentially what the speech was about, right? Now, in this, the Supreme Court firstly overruled this case and this case and this case. Supreme Court said, sedition is perfectly constitutional. Sedition is perfectly constitutional. The only thing is, it will only be sedition if it leads to a violent act. If violation of public order or distortion of public order happens by violence, and that is because of a speech or anything anybody has given, only then will it be seditious. So the Supreme Court played a balancing act. So on one hand, the Supreme Court said, you know what, sedition is constitutional. And on the other hand, it said, but it is only seditious if it leads to a violence-fueled public disorder. Trying to balance both ends so that people don't misuse seditious law, and at the same time, there is no threat to the government as such. And honestly, this is where the law on sedition stops. Okay, this is where the law on sedition stops, and that is it. After that, there has really not been, any change to what the law is. Now, in 2016, an NGO called Common Cause, an NGO called Common Cause, filed a petition in the Supreme Court and said that we must declare Section 124A as unconstitutional because governments and police agencies are not following the Supreme Court judgment. They are violating the Supreme Court judgment. People are being booked for sedition even when there have been no acts of violence. The government is allegedly misusing the provisions of it. That is why students, journalists, intellectuals, all of those are not getting the freedom for free speech. And it requested the Supreme Court that if you want to keep sedition, then there must be a framework. There must be a detailed set of guidelines that the Supreme Court must give, like how you gave for Vishakha's case. So you must also have guidelines for the police, for the magistrates, for the law enforcement in general, so that everybody, the courts, everybody, on how to deal with sedition, how should the cases be taken in, how should people be prosecuted, and so on and so forth. The Supreme Court, however, said, boss, Kedarnath is enough. We don't need to get into this. It is perfectly okay. Let's not bother. Right? So this happened in 2016. Now, in 2021, a group of lawyers led by Aditya Ranjan filed a petition in the Supreme Court, again challenging the constitutionality of sedition. Now, the Supreme Court said, boss, you are an individual lawyer who's come to the Supreme Court. Have you been charged with sedition? Has your friend been charged with sedition? You need to come back with a more substantial case. Then we will perhaps hear the case on sedition. So the case was temporarily dismissed. But between 2016 and 2021, something happened. And this is during the pandemic. The Vinod Dua sedition case. So basically, Vinod Dua, a veteran journalist, his daughter is also a very, very popular, entertainer called Malika Dua. Anyways, so in the Vinod Dua case, what basically had happened was that a BJP MP, I think a BJP member, a party member of BJP, had filed an FIR against Vinod Dua for a video that he had uploaded on YouTube, criticizing the government and the Prime Minister for the way the pandemic was being managed, the way the pandemic was, being administered and responded to by the government. And he, of course, said that, we should, we could have done it better. Everybody has failed us. And of course, there were a lot of loopholes. Why were the hospitals not ready? Why were vaccinations not ready? Why did we not stock up injections? Why was there such a information asymmetry? Why were so many migrants walking on foot? So he made a very, very compelling video. Now an FIR was filed. Now, if an FIR has been filed, then you can only go to the Supreme Court or go to the High Court seeking for the court order to quash the FIR. Now, when Vinod Dua was a very smart journalist, his lawyer was also very smart. So they went to the court and they said two things. One, first, direct the police to cancel the FIR. And two, it asked the Supreme Court that I am a senior journalist, and any senior journalist with a 10-year experience, right? If there is a sedition charge, then there must be a screening committee. There must be a committee that should be formed, or a committee that must exist, that must approve of sedition charges against senior journalists, so that they're able to, function independently and question the government as and when needed. And in my very humble opinion, this was a missed opportunity, because this would have really, really, given a lot of structure to the sedition law. That, okay, we will not, harass journalists If you're a 10-year experience plus journalist, then we'll have a screening committee to sort of make sure that you're not unlawfully targeted, right? So that is the case, and this is the law on sedition. Anything beyond this is not relevant. For the exam, 1962 as a reference point, 2016, the missed opportunity here becomes your way forward or your conclusion, and 2021 as your introduction context, right? And there you have your answers on sedition. So should sedition be removed or declared unconstitutional? What you can say is no, but there should be detailed guidelines, and the guidelines of Kedarnath should be properly followed, and also at the same time they should be used in the rarest of the rare cases, because of the propensity of the people to cause a lot of public disorder. Are we okay with this? Do we understand this? Is this fine? Yes. This is your law. So this becomes your introduction, this becomes your body, this becomes your conclusion. In your introduction, you can write about this and the recent 2021 judgment that it was recently challenged, but the Supreme Court did not entertain it. There you go. Done. इसके ऊपर ना यूपीएससी में एक लाइन आएगी, ना आपको जानने की ज़रूरत है. And I've also told you exactly यहाँ पे. अब if this was a law optional class, तो मैं इसे सीना फाड़ के हेकलर्स वीटो, लुजियाना एंड अलाबामा जजमेंट्स ऑफ द सुप्रीम कोर्ट, द रीजनेबल टेस्ट, ये सारी चीज़ें मैं आपको पक्का कराता. बट ये ऑप्शनल नहीं है ना, ये पॉलिटी है. तो मैं भी दिल पे पत्थर रख के आपको लिटिल पढ़ाएगा, क्योंकि लिटिल एग्जाम में आएगा. सो वेलकम टू द स्टोरी ऑफ सेडिशन. हो गया बस, डन. All right, okay, clear? Okay, thank you. भाई हो गया. ठीक है सर. ओके.